Welcome to our Life First Canada podcast. I am Karen. Tonight, I'm honored to have an incredible guest back with us on our podcast this evening, Julian Swan, and he's going to be discussing pure, irrevocable, non-statutory equity trusts. Everyone is interested in this topic, so this is great. I know many of our members and listeners are excited to learn more about how we can feel more secure in these times of profound change that's upon us. And now, I just want to say that before we get into this amazing presentation, I want to say thank you to everyone who attended the Sovereign Living Conference. It was so incredible last weekend. I know it's unfortunate that it is our final conference. It is a lot of work, and that was our sixth Sovereign Living, and it was great to end it on a high note. As so many living men and women said, it was one of the best conferences that they'd ever attended. Yeah, it was amazing. And everyone, of course, at the conference received the Sovereignty Activation Manual. And this is actually the manual that's for our private members. And we are starting Module 1 tomorrow in our private member group. Very, very exciting. The manual I put together is, well, it has 8 modules. And thank you to Esther for her profoundly brilliant editing. And of course, Karen read through it and added some amazing templates. So we're really, really excited to be offering this to our private members. There's health sovereignty, there's mental, emotional sovereignty, there's wealth sovereignty, there's spiritual sovereignty, there's physical sovereignty, everything in one book. And this is really what we're going to be focusing in our private member group. So yes. I just wanted to say that I was sharing with Esther and Karen that one of our private members had canceled a few months ago, and now she's renewing because of this amazing manual. She said to me, "It is so beautiful." And she's so grateful on how all the content is put together so well, so that she can have a deeper understanding of all these different concepts that we've been talking about for the last 4 or 5 years right here. So again, we're going to be starting with Module 1 tomorrow. If you'd like to join us, I highly recommend you become a private member at our website, lifeforcecanada.ca. And the link is going to be in the description box on our YouTube channel and our Rumble channel. And Karen will be putting it Karen's put it in their chat already, so thank you, Karen. Yes, sovereignty is not a rebellion. It is reclamation and remembrance. Definitely. Okay, everyone, take a deep breath in of life force energy, letting go. We're so grateful to have Julian Swan here once again. He's going to be discussing, as I mentioned, irrevocable non-statutory equity trusts. You're going to learn the basics of trust, the various forms in which they are offered, and you're also going to discover the most important difference between trusts, associations, and ministries, and to find out how Canadian trusts are different than American trusts, and then why combining a trust with equity practices creates the greatest vehicle for privacy and protection. And Esther is going to be hosting the Q&A portion once Julian is complete with his presentation. So if you do have a question for Julian, please put it in the chat, write the word question, and then we can get to those questions after his amazing presentation. Thank you again, Julian, for being here. You can add more about who you are and what you do, etc. I think we've been waiting for a long time now to have you here. So the room is yours.
All right, thank you so much. Thank you, Karen, Esther, and Karen, and all Life Force members for having me on tonight. Yeah, it's been a while. You guys stay booked up. I know this is a very popular platform, so I'm excited to be here tonight. I'm gonna go ahead and share my screen, and I have to request. I'm requesting a screen share.
Oh, there you go.
Cool. All right, I got a whole slideshow for you. Before we get started, just like to open us up in prayer. So thank you so much, Almighty Lord, Father God, for the beautiful hearts and souls gathered here tonight. Thank you that everyone here has the courage to look beyond what they're taught by society, look beyond what we all came up in public school with. Everybody here had the courage to say, something's not right here. And even if it costs me ridicule and financial opportunities, if it costs me my job, if it costs me friends, I don't care. I want the truth above all else. And that is the one thing that everyone here shares tonight, Lord. So I just thank you for putting the seekers' hearts in these lovely men and women here tonight. And I just ask that you guide them in the fullest expression of their potential as truth tellers, truth seekers, as healers, um, and bulwarks for the righteousness that you have instilled in all of us here tonight, Lord. Lord, we hunger and thirst after your righteousness. So help us to find the truest expression of who you called us to be, and help us to find out ways we can protect our mission that you've put us here on earth for, um, figuring out ways to safeguard our families. And Lord, just guide us into that. Teach us the knowledge that you have preserved through millennia, Lord, that you have protected from censorship. And speak through me tonight, Lord. In Jesus' name, we thank you. Amen. All right. So we teach the equity trust system. This really builds upon the equity jurisprudence that we teach. We gave a presentation about that here a few months ago. So the equity trust system combines multiple trusts working together in tandem, written in equity jurisprudence to provide absolutely the highest level of privacy that we can obtain. So we're going to start with some basics, and then we'll go deeper. So first, we have a quote from Gary Allen. He wrote a book called The Rockefeller Files. He said, only a handful of attorneys in the country know how to establish the type of trust the Rockefellers have. These specialized trusts are most emphatically not the sort your friendly local solicitor can create for you. They not only can eliminate probate, cut inheritance taxes, and reduce income taxes, unlike corporations, they can achieve almost total privacy. With a little effort, taxes disappear. With more effort, even the value of the holdings can be completely hidden. Now, Rockefeller may have been a US industrialist, but as all you students of history know, the Canadian and American industrialists are always intermarrying with each other. Um, Famously, the Prevosts and the Burrs way back in the beginning of our country, and it's been a sordid tale ever since. So we're very interconnected, and of course, so are the ruling classes of both of our countries. This is just a little picture of me and my wife here. We teach these classes together. My name is again Julian Swan. My wife Margaret and I wrote the classes, teach them, run the ministry together. So we're going to talk about some basics of trust. We're going to get into the type of trust system that we teach. Some basic concepts of liability and protection and contracts, and how things are different in Canada, how similar things are, but there are some important differences as well. And we'll talk about a few other things, the types of trusts that are out there, and maybe some common pitfalls to avoid as well. Just some things that all of you are going to be able to use to avoid some of the maybe more popular but also more precarious situations on offer out there. So of course, we know the laws of money for keeping and accumulating an estate would be to protect your assets and property, to protect yourself against lawsuits, to avoid probate and estate taxes, reduce income, CPP, EI, and any other Quebec specific taxes. Be prepared for secure retirement, establish privacy as well as we can, and utilize wise counsel. Now, most of the way that people try to do this is by using statutory trusts. And I've seen people pay tens of thousands of dollars to have an attorney set up a statutory trust that essentially all it does is avoid probate. It doesn't really shield the person from tax agencies or government oversight. I mean, it'll get your name off of properties, so that's one other little benefit. If, they'll keep you private from your fellow man, but when it comes to tax agencies and the government, it's just treated as an extension of you. They still know exactly who you are and who's benefiting from the trust. It's typically set up by an attorney, costs quite a lot of money, may grant you a few privileges, but is fully created by state authority, and so it is subject to state authority. Of course, we talk about in the equity class how there's a difference between at law and in law. And if you look at their definitions in Black's Law and Burton's Legal Thesaurus and so on, you'll see that equity is distinct from at law. And there's a synonym of at, which is near. So it means just near the law. So you see an attorney at law, that's just an attorney near the law. Equity is in the law. So very much more solid foundation for us to stand on. So, of course, we don't want a statutory trust, but we're going to talk about, a few people that set them up here. Overly educated professionals, financial planners. Of course, any information that the CRA gives you on trusts is going to be just telling you how to better fit within their laws and their rules. Estate planning is a very popular thing to spend money on, but again, really all it does is just avoid probate. These are typically going to be revocable trusts or what's referred to as a living trust. Living is really just an adjective that means that it goes into effect in the lifetime of the grantor. But when you see like a capital L, capital T living trust, it really is referring to like a popular form of a trust that's revocable, that's usually grantor controlled, that's set up by an attorney. And yes, it goes into effect during the life of the grantor, but it's treated as the same thing as the grantor for tax purposes. So it doesn't do anything to avoid income tax or anything like that. So living trusts hold real estate. They don't operate a business. They don't avoid state taxes. They're revocable. They don't avoid statutes and regulations. No asset protection, not tax-wise or tax-safe. They share power with others, including the province and the federal government, and offer very little liability protection. And really, they don't even they say they avoid probate, but if it gets challenged, it's still going to probate. So it's really not that useful. Same thing with estate planning. I mean, it's just going to involve setting up statutory trusts. It offers very little control. And again, attorneys and lawyers really can only tell you what they know about. Same with the CRA. They just tell you how to fit within their rules and regulations better. We're going to skip that. Now, there's a few alternatives to the statutory trusts on offer out there. Obviously, we're one of them, but a very common alternative that we see is the common law trust. Now, typically, the common law trust is set up the way I've seen out there is they will make you the trustee of your own stuff. So, of course, this is your first foray into more private trusts. You're leaving the statutory realm, but they still make some pretty grave mistakes. If you make somebody the trustee of their own stuff, you're really just violating the fiduciary role of the trustee right off the bat. I mean, a trustee is supposed to be independent, and if a trustee is not an independent, neutral third party, then they're at least supposed to have a few other trustees on the board that are. Otherwise, it's just there's no separation there. The entire point of a trust is that you are giving away your stuff, getting it out of your name, relinquishing it to a neutral third party for the care of maybe your children, your grandchildren, whatever. And you're allowed to set forth the rules by how that money, that govern how that money is used and when it's paid out to the kids and the grandkids. But you're not supposed to be touching it after that. And so typically it's your stuff, and they put you in the role of the grantor because you're putting your stuff in a trust. Maybe they have you do a switcheroo with a friend or something before it goes into trust, but it's still pretty easy for a tax agency or a court to trace that. And then they make you the trustee because the trustee's in control of everything. And of course, they know everybody wants to control their own stuff. So they're just going to make you the trustee. You're in the hot seat. And then you're also the beneficiary because you're still benefiting from the stuff. So there's really no trust there. It's just like, I put my money into my pocket with my right hand and I only take it out with my left hand. I mean, it's just kind of silly. The trustee has a lot of responsibility, especially in Canada, because we're going to talk about in a minute how the trustee has even more liability in Canada. Uh, but you really don't want to be in any of those three roles. You don't want to be the grantor because that's going to be scrutinized by tax agencies. You don't want to be the trustee because that's going to be scrutinized by everybody, courts, tax agencies, governments, even just people you're doing business with. And you don't want to be the beneficiary because again, it gets, going in and coming out, grantor and beneficiary gets scrutinized by the tax agencies. And beneficiaries have no control over anything anyway. They're not supposed to have control over anything. That's the whole point. So if somebody's telling you to be trustee of your own stuff, I would be highly skeptical of that. And just look at the adverse trustee doctrine. You can look up cases that have been lost over the adverse trustee doctrine. You can look up, the fiduciary role of a trustee. It's going to describe things that have nothing whatsoever to do with being trustee of your own stuff. So I can't harp on it enough. It's very, very common out there, and it is fundamentally flawed. Um, so that's one of the more popular options out there. There's another option, again, leaving the statutory world, going to the private realm. You'll see this on offer sometimes, is people that combine a trust with a ministry. Now, this is more popular in the United States because people have this misconception about 508c1a ministries, which is just IRS code, so it has nothing to do with Canada. Ministries do get certain benefits in Canada as well. They're more limited than in the United States. Uh, but there are some benefits. However, you have to register that ministry if you want to see like property tax exemptions or certain like GST or sales tax exemptions. They do exist, but you have to register the trust, which makes it a public entity, not a private entity. They're going to want to see statutory elements of the trust. Probably they're going to want to see that it was set up by an attorney, not always. So it just kind of takes all the benefits of being a private entity and gives them away in order to confer a few property tax benefits that may or may not stick once they see what else you're trying to do. So that's a little more popular in the US, but I have seen it on offer in Canada as well. Biggest thing about Canada is that the trustee is supposed to hold assets in his own name. Now it'll be John Henry Doe trustee in trust for Standing on the Rock Trust or whatever. So it'll still be the trust name on the deed or on the vehicle registration or whatever it is. But the trustee has a little bit more liability. But we're gonna get more into that in a second. Ours also obviously is not a statutory trust, and we're departing the public realm, going into the private. So what makes ours different, and why do you need it? Well, it's going to be the absolute best way to own and accumulate assets while separating the liability from the different properties and vehicles and whatsoever that you hold. There's going to be no interference from the state. You'll be able to organize and operate a fully protected business no matter where you are. Of course, it gives you the ability to pass things along to your heirs, but statutory trusts do that too. So let's move on. Avoids estate tax. It preserves family heritage, of course, is a great way to get the family involved in what you're doing. And you can organize it without exorbitant attorney's fees, which are pretty crazy from what I've seen. So we stand on a few different, people that have come before us and been doing these things for a while. There was a big teaching in the 1990s in the United States that centered around the common law trust, which was based on a Massachusetts trust style. They made a lot of mistakes. They still filed forms with the tax agencies, which is a huge mistake. You never want to. Of course, if you're going to stop filing with the CRA, you want to have an actual remedy in place for when they complain about it. But the best option out there is to stop contracting with the tax agencies. And the equity class that's separate from this, we can teach you how to do that in a way that will help you discharge that tax bill. Um, but you never want to be contracting with the tax agencies, and you certainly don't want to be bringing a private process like equity and paying taxes with your Canadian dollars at the same time. Because it's just double-minded. You're already paying with the acceptance process that we use. So it'd just be double-minded and look like you don't know what you're doing if you're still paying with Canadian dollars at the same time. But that's all just various methods that I've seen out there. Let's talk more about why a business trust in particular, because that's one of the major trusts that we use in our system. Business trust is going to help you consolidate management. It's going to be able to separate out the front-facing part of the business from the managers. You're going to be able to avoid all the difficulties and costs of transferring property because it'll be handled privately. Of course, you still avoid probate and estate taxes. It's a great way to steward the family goals, to have everybody have a shared enterprise together. If everybody has a role in the trust, then the kids like to get involved and learn what you're doing, and we've seen that a lot. It's really great. Of course, we're going to set it up in a way that provides maximum liability protection, gets your name off of everything, and helps you to interact with the commercial world in a way that does not ping the CRA system every single time you do something. So there's certain forms that need to be filled out when you buy supplies from somebody, when you sell supplies to somebody. They're going to want to ensure that they're being tax compliant because obviously they've been browbeaten like most people to think that they have to tell the CRA about every little thing that they do. So we're going to help you to provide them the information that they need to see in order to keep doing business with you, but not ping the CRA system in your name. And there's various ways to do that to just minimize your exposure to the commercial world. There's certain ways that certain tax forms that we use to give to a supplier. These things don't get sent to the CRA because I just got done saying how you don't want to fill out their forms and send them to them. Obviously, there's certain forms that you need to show to a supplier or somebody that you're doing business with as a contractor, if that is your industry. But those things don't get sent to the CRA directly, certainly not by you anyway. The person that you're dealing with does take some information off of that and put that on another form and send that to the CRA, but we can't really help that. So what can you do with the trust? It's going to be the absolute best way to not just keep your wealth, not just earn wealth, but keep your wealth, to manage your assets, to accumulate wealth over many generations. You can use it in conjunction with whole life insurance policies in some really interesting ways. Some of you may have heard of the infinite banking concept, really cutting edge stuff, and it is applicable to Canada as well. Avoid dissipation of that wealth from taxes, from various liabilities that any other statutory entity is gonna have to deal with, like GST and all that kind of stuff. You're gonna be able to run your business without provincial licensing requirements. You get to stop paying in the CRA system every time you do something. You hold property and operate fully in the private. Keep it out of your name. I did talk about, the trustee has a little bit more liability in Canada, but we're gonna discuss a very important case precedent in Canada in just a moment that limits that. Of course, this can help you stop withholdings if you're an employee. We have another way that we teach to do that in the equity class, but there's an even different form of it that you can use with the trust class that is a little bit more effective with the more ornery employers that don't want to take the form that we use. In equity, there's a way to set it up where you're getting paid through the trust, and you use a certain tax form with the employer that does not get sent to the CRA, but that can put them more at ease than just the way that we handle things normally in equity. And you'll just be able to build more without fear of catastrophe or invaders from the government or dissolution through taxes and the passing away of people involved in your system. So what we offer is true liability protection. You transfer ownership to an artificial entity. You use a system of layering multiple trusts and potentially PMAs and ministries to offer maximum liability protection. And we exploit certain loopholes, and loopholes are not bad words. Where loophole is just something that somebody came up with because they were mad somebody else was doing smart business and not having to pay the fees that they were paying. I did want to cover just real quick. This is all based on contracts. Um, in the United States, we have Article 1, Section 10, Clause 1 of the Constitution, which says that no state can pass any law impairing the obligations of contracts. And of course, people in Canada sometimes say, well, this isn't in our charter, but it's actually been upheld in basically the same capacity by the Canadian Supreme Court. And this was actually a recent case too, so it's not going too far back into history either. It was a case, Basin versus Hryniu, and it was about good faith and contractual obligations. But one of the Supreme Court justices of Canada just stated it openly that there's a basic principle of freedom of contract in Canada, regardless of whether it's enshrined in the charter or not. And just because it's enshrined in our Constitution doesn't mean it's unassailable. It was assailed plenty throughout history in America. And that's another thing we talk about. I mean, maxims of law, people teach them as if they're like rigid, set in stone. But in the trust class, we really go into the ways that maxims have been kind of tweaked by case precedent over the decades. Um, like everybody knows the maxim, equity will not complete an imperfect gift. Well, sometimes it will. I mean, that's really about property not being transferred, right? But there's plenty of case precedents where equity did complete an imperfect gift. So they're always coming up with caveats to these things. There's a lot of equitable maxims that people like to throw around. Usually the list is like 12 or 20 maxims long, and they get applied in a kind of narrow way by most people, but we really go into depth on those maxims in the trust system class so that you understand the play that you have when you're dealing with a court and the play that they're going to try to use against you with those maxims as well. Of course, we're all familiar with the Rockefeller quote, the secret to success is to own nothing but control everything. Nobody knows if John D. Rockefeller actually said that, but the point is the same. With most trusts, you either technically still own it because you're wearing too many hats. That's what we talked about before, where people try to set you up in multiple roles, or they have it set up where you just give away everything to a trustee and you don't get to control anything. That's another trust type that you see out there, even in the private centric world, where you just hire a trustee and give everything to him, and you're not supposed to do anything but be a beneficiary. Less liability, but again, you don't get to control everything. So we have a way of helping you control your whole business, everything in your life, but not wearing the grantor hat, the trustee hat, or the beneficiary hat, and having all the liabilities associated with those roles. There's other roles in a trust, and we really flesh that out in the class. Obviously, there's many people that can benefit from this. One very popular area or gaining in popularity is the alternative health sphere, especially after the whole fake virus and everything that happened a few years ago. People are really looking for ways to, healers, medical practitioners, who have a real gift for healing, but maybe they've tried to corral them into an allopathic system that doesn't truly, express that talent. They're coming out of it and they want to know how they can help people and still be able to do so without being attacked by the state. There's some pretty unique ways that we use to get around those attacks when it comes to healthcare. Um, but if you are in alternative health, we can definitely help you. Um, keep helping people, but not fall into the same pitfalls that so many of your peers have. And just specifically dealing with Canada, I wanted to bring up some things. So, from what I've seen, it's like, how do I put this? In America, the freedom movement, as it were, has been around for maybe 50 years. I mean, things were really good in the 60s here, and it didn't seem like people really had much of a reason to even look at these things. I'm sure if you go back, you can find something, but really the first inklings of it that I've seen were really got big in the 1970s. And people tried various things, but it wasn't until the 1990s that you really saw it take off with the origins of things like secure party creditor, um, which there's some good and some bad too. I mean, there's a lot of truth to some of that stuff, and things that we actually have built upon. So we of course stand on the shoulders of giants in the equity class, but there's a lot that fell short. And I know secure party creditor and various other techniques are very popular in Canada right now. Um, but it seems like it gets tried in America, it gets exported to Canada, and there's just there's kind of a lag there. And if you really keep your ear to the ground on various processes out there, you'll see that mostly what happens is they see some initial success for a couple years, and then the courts figure out how to, what's going on, how to adapt to it. They really explore the foundational components of what these people are doing. And typically they're going to find that they're still violating some kind of contract they got themselves into. You have a birth certificate and an SIN. And because of those contracts, you're in a very particular position. You are what's called a voluntary surety. You can say, well, I was just a baby. How did I volunteer for this contract? Well, as you got older, you began to use the benefits of these contracts. And specifically with the SIN, I mean, you used it to set up a bank account. You used it to get a driver's license. You used that driver's license to, maybe fly on a plane or rent a car. There's just a number of ways that you've accepted the benefits of these contracts. And so these other processes out there, some of them do recognize these contracts. They try to get out of them. They try to say, okay, well, I'm going to try to claim my estate, or I'm going to try to unmake all those contracts and just start fresh. The problem is that with the unmaking of the contracts, you're already in the system. If you do unmake them, you're going to have to stand on that for the rest of your life. Every single time you get pulled over, every single time you try to get something filed, every single time you try to fly on a plane, every single time you want to go into a courthouse and witness a case, you're going to have to show ID if it's like a federal courthouse. And it's going to be a problem because you're not going to have any of that stuff. And you're going to have to stand on, use your family Bible or whatever form of identification you're using. The problem with reclaiming the estate is that it's not yours to reclaim. It says at the top of the birth certificate, the province of whatever. It's I've never heard of anybody like actually being able to claim those millions of dollars. Now, there's ways that I've seen people operate in it that has been effective, but it seems like it's a lot of hit and miss. So I guess where I'm going with this is that in Canada, these things have been tried, but they've been tried and tested in America for since the 1990s. A lot of this stuff, and it's very hit or miss. Something like equity is a lot newer in America, but especially in Canada. And there's always a testing time. So one thing we all have to remember is that no matter what country you're in, there is going to be the necessity of standing on the rock with whatever method you choose to use to interface with Babylon. The taxation agencies are not going to tell you how to protect yourself or how to avoid taxes. The governments and the lawyers are not going to tell you how to organize your business and your family assets in order to stay private. as moral sentient beings who reap the fruit of our labor, we don't fit into any of their jurisdictional categories. I mean, nothing about the CRA was set up to recognize, men and women who enjoy the fruits of their labor. It's all commercially charged words like income and gift and remittance and all this stuff. So we don't fit into any of their categories. And if you want to fit into their categories, fine, no problem. But if you want to opt out, then it's going to take some research, some deep internalizing, and some practice. Now, we've had a lot of Canadian students go through our most recent class, and they've really only had about 2 months, 2 or 3 months to begin applying the process. So we have a couple of early wins that we can share with you all. And some of the people I learned from also taught Canadians who saw some great wins as well. But there is still a proving period of equity in Canada. What I can tell you is that it has been incredibly successful in the United States, in Australia, in Ireland, in New Zealand, and there's no reason. I mean, if you want to say, okay, things are different in America versus crown countries, fine, I'll give you that. But we've proven ourselves in crown countries already. So we just got a big influx of Canadian students a few months ago. They've had about 2 or 3 months to get their feet wet, get started. We're working with several of them on that. And we do have some wins that we can share with you. But most of our wins in crown countries that I can share with you come from Australia, Ireland, etc. So I just want to put that out there. But when it comes to specifically Canadians, the end result is that we all have to stand on the rock with what we're doing. It's essentially the same. I mean, there's very few things about Canada that are truly different from the United States. There's some things that are actually easier. There's some things that are harder as well, like notaries, for example, or the process is insane. I mean, it's kind of cool actually. You have to like go to university to be a notary, and there's like not that many of them, and even fewer that are actually going to notarize your stuff for you. Thankfully, there's only one thing that we even get notarized in equity. So it's not like you're going to have to constantly be, running up against that wall. And we have people that have already, gone before you and found some Canadian notaries. But in the United States, like anybody can be a notary. So that's definitely one thing that's harder. One thing that's easier is that Canada has the Bills of Exchange Act, and I'm sure all of you are very, very familiar with that. There's really no specific Bills of Exchange Act in the United States. I mean, the Federal Reserve Act has a little bit of it, but it does make it easier in Canada for them to recognize what we do in equity. There's a very particular way we do a bill of exchange. We don't even really call it a bill of exchange because it's done very specifically the way a bank would do it with another bank. But there's a few differences that we've hammered out, but the process has been fully adapted for Canada. It's just a little bit newer to Canada, so that's why I talk about the testing period. But another thing to remember is that equity's maxims are universal. The history of equity and the history of trust is the same for all Western countries. It all comes from England. The terms and the definitions are all ubiquitous. And even US and even Australian cases, they have precedence, they have persuasiveness in Canada. Canadian Supreme Court justices do often reference United States and other foreign jurisprudences, especially in regard to constitutional and human rights cases. So Canadian courts have stated that they consider US precedent to be persuasive but not binding. And one of the funny things about Canadian law when it comes to trusts is that Canadian law treats trusts as relationships, not entities. They say that trusts are treated as an extension of the person when it comes to property rights and the like, but they're treated as individuals when it comes to tax law. So in other words, the Canadian authorities try to say, well, for everything that benefits you, trusts are the same as you and you don't get those benefits, but everything that benefits us, they're separate from you. Of course, when you look at actual case law, it's a little different from that. So that's just the information that you get if you pull up the CRA on trusts, or you look at like an attorney's website about trust. But if you look at actual case law in Canada, it's not that rigid. They're just trying to scare you. Just like if you searched on ChatGPT in America, of course, ChatGPT is funded by Google. It's just about the worst thing you can use to search for your questions and let it speak into your life. It's going to tell you to get vaccinated. It's going to tell you to vaccinate your kids and your pets. It's going to tell you to pay all your taxes and go above and beyond and all that. So we have to look a little deeper. So here's a very relevant case for Canadians. It's called Goldman versus the Queen. It's from 2021. And the issue in this case was whether a trustee is personally liable under the Trust Act for tax debts when a grantor transfers assets into a trust. The conclusion was that the trust itself, not the trustee, is the one that incurs the tax liability. So trustees are not held personally liable for trust tax debts, just like in Australia, just like in the US. They are shielded unless they personally receive or misuse trust assets. Again, same as the US. There's supposed to be a separation. You're not supposed to mix trust assets with your personal assets. There has to be some formalities that are observed. But a quote from the trial stated, quote, "The trust tax debts belong to the trust itself. They aren't personal debts of the trustee," end quote. So even though they word things a little bit differently in Canada, the outcome is still the same. And we just need to learn to navigate around the terminology and the often complex and contradictory statutes and codes. I mean, it's contradictory to say, it's treated as an extension of you for anything that might be useful for you, but then it's treated as an individual for tax purposes. Um, we haven't seen that to be the case in our application of trust law in Canada. They can say that rigidly on paper, but any statute is only good as an attorney can argue in court or as an equity jurist can discharge in court. So it's also important to note that Canada does not consider a trust to be a UBO or an unincorporated business association because a trust is a relationship. So even though Canada requires UBOs to register, they cannot require a relationship to register with the state. So again, like if you just look it up with the CRA, oh yeah, you have to register your trust with the state. But when you start digging deeper into it, there's the same protections for trusts in Canada as there are for the United States. The problem is when people ask AI, they're going to get the prevailing information out there. Whatever the majority opinion is online is what they're going to get. In the United States, there's a little bit more dissent that you see online. But when I do AI searches for Canada, it's very rigid. So it's still quite a small minority of voices that are speaking up about trust in Canada. So we're going to add to that minority. We're going to make it a more vocal minority, especially with your help. So just some considerations for Canadians. That was kind of a long way around the barn, but just to say that it is generally about the same, and the few differences that there are, we have fully fleshed out. So that's about it. I mean, this is all the stuff we're going to cover in the trust system class specifically. I gave you some things tonight, just at no cost, because you all showed up tonight, that are going to help you avoid some of the worst pitfalls out there. Like again, look up the adverse trustee doctrine. Look up the alter ego doctrine if you want to think about wearing multiple hats in a trust, which you should never do. You're going to see many cases lost and many people's livelihoods destroyed because of these mistakes. Making you the trustee of your own stuff, wearing multiple hats in the trust, not having degrees of separation. So those are definitely some things to avoid. And I mean, if you want to do the research yourself, like you can put this together yourself based off the information that you've got here tonight. I'm not going to say it's going to be easy. I mean, but that's the whole point of classes, right? We give you a shortcut to the knowledge to give you the gems so you don't have to sort through the garbage like we had to. So our class, if you choose to join us, the Equity Trust System class, will cover all of these things and more. Enrollments are going to be opening in a couple of weeks. Of course, the equity class is a prerequisite because it teaches you how to deal with taxes and all that. But using both in conjunction is going to give you absolutely the greatest protection that you can possibly have. When you combine proper trust setup with the equity that we teach, you're going to approach a level of sovereignty that has not been seen in over 200 years. And so this is our contact information, and I'd be happy to answer any questions and dive deeper on some more Canada specific things if you like, or anything that we can do to help. So thank
This
you
is
very
so
much.
great, Julian. Thank you so much. So I did have a question earlier, and it was from one of our members in regards to the word irrevocable. And I just wanted to clarify with you that it means that the settler can't later take back the property or change the terms without the beneficiary's consent. That's correct, Julian, right?
Yeah, there are some exceptions to that, but for the most part, yes.
Okay. Okay, I'm going to hand it over to Esther. We got quite a few questions in the chat.
Great. Thanks, Julian. You're always such a deep well of information. Okay, first one. On slide 5, Ian asks, why only Quebec-specific taxes?
Well, I named a couple of other tax schemes that are Canada-wide, and then Quebec has like its own little version of those. Um, it was it was like some kind of withholdings, I think, and then Quebec has just a slightly different version.
Okay. Deborah is saying thank you so much for coming. She really wanted to hear about this evening. Can she put a condo into a trust, a condo that she owns, and there's no mortgage on it?
Yeah, absolutely.
Okay.
Condo is a little more difficult to get a land patent on, but certainly you can put it in a trust, and that's going to provide quite a lot of protection for you.
Great. And another question, if people already filed secured party creditor paperwork uh, on something that is registered in the US with UCC1 filings on themselves and their assets, can they still use equity for things like taxes owed to the CRA or debts?
Um, Sorry, what was the caveat about the UCC one?
Uh, if they've already filed security,
Equity gives you the ability to rescission. If you've made things that you have determined now are a mistake, maybe they've come back to bite you in some way. Those things can be unmade, and you can start it off on the right foot. With UCC ones, you don't really even need rescission to unmake those. I mean, you can just do a UCC3 termination if you're really wanting to get rid of it. Also, I just for the last question about the condo. There is the consideration of the HOA. Almost all condos have HOAs. That makes things a little trickier. But the equity that we teach can help you deal with them and put them back in their place, as it were.
great. And HOA is homeowners association.
Yes, yeah,
Thank you.
very unruly people.
I love it. Christina asks, what purpose can a trust serve to someone who has no assets or wealth other than strength, wisdom, and love?
Well, privacy for one. I mean, we're coming into a less and less private world every day. It's going to help you to. I mean, I'm sure you have some kind of income to survive, so it's going to help you to move that income around in a way that doesn't ping tax agencies to where they even if you don't have much to take, they're still always trying to take something. So yeah, privacy and protection for what you do have.
Okay, thank you. Carol asks, with the United Nations Declaration on the Rights of Indigenous Peoples Act at the federal level in Canada and in BC, with the government working on the DRIPA action plan regarding property, what might the implications of putting property assets into a trust be?
I mean, there's always new laws that are being passed. I mean, new offers that are being made to you from the government. I mean, there's always, down here, our counties are always coming up with new regulations, telling people, they can't have certain things in their yard, or they have to get a permit for certain things. I mean, the equity that we teach is plenty capable of discharging those issues. If it's more like you mentioned like a Indian natives kind of angle. We've worked with Canadian students whose land is on Indian land. I mean, it's nothing new to us. Um, so if there's some kind of new law coming out that's got some new restriction or whatever, the equity that we teach can help discharge whatever they're trying to offer you.
Great. And if somebody doesn't want to take your trust class, but just wants to hire you because they don't want to do it, is that possible?
So one of the reasons that we started the class is because we took other classes out there, and the problem is they write a trust for you and it just sits on the shelf collecting dust because you don't understand why they wrote what they wrote into the trust. You don't understand how to use it day to day. And without that intimate knowledge of the actual working components of the trust, it's just going to collect dust. And then if you get a problem, you just go blame that person because they didn't teach you, which they should have. So our class goes deep into how to write it yourself, and so that you're never beholden to me or to anybody else to write it for you. And then we go deep into actionable information about how to use it day to day. So, that being said, we can still write one for you, but we do require the class as a prerequisite because that way you're going to have an intimate working knowledge of everything in there, and you're going to know how to use it day to day, which is so important for you to actually use it in your life.
Thank you. Joanne asks, you said you don't want to be grantor, trustee, or beneficiary. So how can you have a trust if you are not any of the parties?
There are more than three parties that are possible in a trust. So you're going to have people fulfilling those roles, but it gets more complicated than that.
So if I were to create a trust and I'm not one of those three things, what would I be?
That is a secret.
Okay.
It's not a secret. Well, I mean, it's something we keep close to the vest because it's very powerful information, and if used outside of um like the if somebody who doesn't understand how to discharge taxes starts using it, then they could actually get themselves into a lot of trouble. That's why we combine it with equity to make sure the person knows how to discharge taxes properly.
Okay, and there's so much to learn, but there you go. Okay. Uh, you mentioned an equity trust where you avoid capital gains and designate the assets to your children, etc. Doesn't this just delay the paying of taxes? Will the children pay the taxes if they gain access to the assets later?
Yes. Well, that's why the children need to learn equity. But yes, once money leaves the trust and goes to the beneficiary, it's taxable to the beneficiary. So that's why the kids need to get involved with the family business and learn how to discharge taxes with equity as opposed to their hard-earned dollars. Or set up their own trust and keep the deference going for generations.
Great. So another reason why you wouldn't just do it for them. You have to know what you're doing in order to proceed.
Exactly.
Christine asks, is this the testing time for equity trusts in Canada? I believe you answered that, but can you expand on that a little bit more?
Well, I mean, I wouldn't say for trusts as much because they've already been used for hundreds of years by your elite banking families, as same as they have in the UK and all over the Western world. We're just putting what they've been doing for centuries in the hands of you all now. So I think as far as trust goes, it's been well established in the Western world. It's just equity is an alternative to doing whatever the government tells you is more of what's being tested in Canada right now. There's already been quite a lot of wins, but as far as kind of spreading at a broader level, that's what we're looking at next.
Thank you. Carol asks, with the US now being a republic, does this impact how an equity trust is set up in the US?
Well, the U.S. has always been a republic, so I'm not entirely sure I understand the question.
Okay, well, with the US being a republic, does this impact how an equity trust is set up in the US?
No, because we're not beholden to state law for the trust. The trust is established on the fundamental right to contract. So we're not really taking our marching orders from the state, as it were. It's just the right to contract that establishes everything that we do. So it's kind of a fundamental right that exists across the Western world, whether it's um, a parliamentary monarchy or what have you.
Okay. Deborah asked another question. This was probably related to the condo one. What if there is no debt in the trust and just assets to protect an income?
Then yeah, absolutely. A trust is going to help you do that. I mean, it's going to, insulate liability from one asset to the next. It's going to, get your name off of them. So any liabilities associated with you, any creditors or tax agencies that are upset with you are not going to be able to touch the assets. If there's a business running out of it, then, that's not going to touch the assets. We have a way of layering things that insulates all the different, assets and properties and bank accounts and such.
Thank you. How does trust differ from having a diplomatic immunity or becoming a world citizen under international law or under God's law, not attached to a jurisdiction or country?
Um, Well, I suppose it's just a different approach. I'm not really too familiar with, the efficacy rate of diplomatic immunity and all that. I know people have tried it and didn't wound up very, very good from it, but I haven't really researched that enough to be able to give you a good answer about, how that does. But a trust would just be a different approach anyway. I mean, a trust is about getting your name off of things, letting go of the assets, putting them in the care of somebody else, and setting things up in a somewhat complex way to still maintain control over those things, but have somebody else be liable to them, the trustee. Um, and yes, it does complicate things a little bit, but once you get rolling with it, it's rather profoundly simple.
Thank you. One of the things in Canada used to be that you could set up a trust as an offshore thing and you wouldn't have to pay taxes. Now the Canadian government, or maybe it's just BC, I'm not certain, has set up some edict that it doesn't matter if you set something up offshore, you're still beholden to pay taxes. Now, I'm sure those aren't the kinds of trusts you're talking about, but can you comment on that?
Yeah, that's going to probably be a statutory type of trust. Also, it's extremely expensive to set up a trust in like, Nevis or Guernsey or one of these, the Seychelles, one of these tax havens. It's going to be tens of thousands of dollars. And yes, it provides privacy, but there's still going to be tax considerations for that. And you're going to need attorneys. And the sort of government oversight that led to the shutdown of, for example, the trucker convoy bank accounts. I mean, that's still going to be possible in most cases. Not in a place like Nevis so much, because they don't recognize foreign judgments. But I mean, if they get a call from, the deputy prime minister, you think they're not gonna do it. So no, we don't require foreign jurisdictions. They can be helpful, but the point is to get your name off of things and, move the money in such a way that it never really touches you. Even if they wanted to shut it down, they wouldn't really be able to know where to look and how to come after you.
Thank you. Would a licensed retail commercial entity, say, for example, beer, wine, or cannabis, be permitted to operate from an unregistered non-statute trust?
So we can avoid business licenses with these trusts, but when it comes to certain other regulatory requirements, it has to be treated on an industry by industry basis. There are going to be some regulatory considerations when you have things like you know uh, beer and drugs like cannabis and all that. I mean, there's just too much regulatory oversight for those things to not do some kind of consideration to that. So yes, we can avoid business licenses, but you're still going to have a public-facing entity that uh, at least pays some kind of lip service to regulations. And we can show you how to do that in the most private way possible. Still keep your name off of things, to still have multiple degrees of separation between you and the commercial realm. But if you're trying to, have a public business that deals in those things, then there's going to have to be some considerations. But we can still keep you totally private and protected even in the face of that.
Would it have to be a trust or a private members association combination? Could it be either or?
Oh, I'm so glad you mentioned that because I wanted to point out that associations are very popular, especially in the alternative health world. But there's nothing an association can do that a trust cannot do, and there is quite a lot that a trust can do that an association is not able to do. There's certain powers granted to trusts that are just not possible with an association. Things like flight clauses and just the sort of separation of liability that comes in the roles of the trust. With an association, the one benefit is that you can start with two people instead of three. You just have to have a founder and a first director, but there's just a lot of limitations when it comes to associations. So yes, I mean we do teach how to set up PMAs in the class if you really want one. There are some benefits to it as well, but for the most part, you would want to trust. I mean, it's going to be absolutely the most powerful entity.
Okay. So along those lines, Mark is asking, could you give concrete examples of the benefits of a trust? And I know you've shared some of those in your slide presentation, but he goes on, for example, let's say someone regularly gets dividends from a corporation. Is it possible to set up a trust, keep getting these dividends and not pay taxes on them?
So first of all, we got to be careful with our language because we do actually pay every penny of taxes that they say we owe. We just do so in a different way. We don't use our Canadian dollars. We use equity. And yes, there's going to be a way for you to, take whatever you're getting in the public and funnel it through a system to where, some entity in that system is going to be liable to pay taxes, of course, because anytime you move money from the public to the private, they're going to ping something. But you're going to be able to, use degrees of separation and have people that you're working with that will handle that public facing side of things and be able to discharge with equity. So that's why the equity class is a prerequisite because there's always going to be tax considerations. Trusts alone cannot solve tax problems. They can shift them to others. They can defer them. They can give you some workarounds. But at the end of the day, you have to have equity to be able to discharge the taxes. So we can have it set up in a way that gets the money to you at the end of the line, and then somewhere else in the line that it stops there, and equity is used to stop it there.
Okay. Having done the equity course, I kind of understand what you're talking about. For those people who haven't, could you give a short explanation further to what you just said about how
Sure.
equity deals with it?
Because of the Bills of Exchange Act and the nature of modern money mechanics, most of the world runs off negotiable instruments. Now, all of you, I'm sure, here tonight have seen, bills of exchange and remittances and, things that people write on vouchers and accepted for value and all this kind of stuff. All of that is at best hit or miss. What we teach in equity, here, okay, let me back up. The reason why it's hit or miss is because yes, it's a valid form of payment. When you write that bill of exchange, when you mark the voucher a certain way, it is a valid, legal, and lawful form of payment. The problem is that you have gotten yourself into some kind of adhesion contract or some kind of just express contract, like a birth certificate or social insurance number, that is precluding, or sorry, that it is offering the authorities multiple avenues that they can choose to use. So yes, you've given them the bill of exchange, but you still volunteered for all these statutory contracts at the same time. So of course they're just going to go with that because they don't really care about your money. They just care about controlling you. They can print as much money as they want. The beauty of the equity that we teach is that not only do we teach how to do a proper, you can call it a bill of exchange if you want. It's an acceptance. We teach you how to do it the way a bank would do it. But more importantly than that, we teach you how to avoid their adhesion contracts so that they're left no other choice but to go with the legal, lawful form of payment that you've tendered. And they have a million adhesion contracts out there. So it's going to take just some very precise internalization of their pitfalls and traps in order to know how to avoid that, especially if you have to go to court and talk to a judge. I mean, a judge has 1,000 ways to recontract with you. So when you're dealing with the CRA, if you bring equity, you're not going to have to deal with court, thank God. Um, but there's still, mistakes that can be made, and there's certain procedures that need to be adhered to, especially if you've already sent them things in the past, which I'm sure everybody here has. Those things need to be dealt with carefully and precisely. So we leave them no other avenue but to accept the particular form of payment that we use. And we do get them paid. I mean, it's something that they can use to get paid. So that's hopefully brief enough, Esther.
Yes. Thank you, Julian. I think that helps put it in context. Sean asks, how long have you been operating?
So we've been teaching for over 2 years. We have about 300 or 350 students at this point.
Great. And how long did you study for in order to start doing this as teachers?
Well, we took a class, and then we also found some other individuals to learn from. So it's a small handful of individuals that we learned from, and then we applied equity in our own lives for about a year. And we saw some victories with the IRS, with a couple of credit cards. And then we felt like we were ready to begin teaching others, at least on, starting out with smaller cases. We won our first case. Is the state of New Jersey was trying to get this woman to vaccinate her dogs, and we helped her discharge the case. She was using, I think, like a pre-1933 kind of Rourke method, and we helped her kind of come out of that and bring the equity that we teach. And from there, it was just off to the races. We started offering a class, and we continued to do research and learn more and more. So I guess you could say 3 years, and 2 of those years we've been teaching, a little over 2 years. And we've greatly expanded on what we've learned. The fundamentals are still there, but there's some directions that we've taken this in that have really shored up some loose ends and made it much, much more powerful.
Great. Thank you. Brielle asks, what is a reasonable amount of time or study and funds would you estimate it would take to learn and set up a trust with you?
Well, the funds question, I mean, you can just go to our website and it lists the prices there. But the time, I mean, I would say, I mean, I'd like to see you do an hour a day, but I mean, everybody's different. I know people that do an hour a day, they do fantastic. And I know people that can only do a couple hours a week and they still manage to do very well for themselves. So, I mean, investing in education, in my opinion, is always the greatest investment you can make. It's the one investment you can make that will have, exponential effects on your life, whether it's finance or joy or just lack of stress. So whatever amount of time that you can dedicate, I think is gonna really help you.
Thank you. We may not get to all the questions, but why do you need to know how to discharge CRA debt first? And since no one has had success with CRA yet, what is the point of using this method?
Well, that's not true that nobody's had success with CRA.
Okay.
There's been multiple Canadians that have. But like I said, with trust, there's always going to be tax consideration. No matter what you're doing, there's always somebody trying to tell you you owe some tax. When you're trying to bring money from the public into the private, there's a certain point along the line where it gets taxed. No matter how many tax deferment schemes you use, that's always going to be the case. And again, like trusts can shift that tax liability around. They can defer it. They can, give you ways of sidestepping it yourself, but it's always going to land somewhere on somebody. And at that point, when that happens, equity is your best friend. So that's why the equity is so necessary.
Okay. I'm not sure how to pronounce his name. Pareik says he missed the beginning of the class, or she, and if this was answered or not, but can you put a corporation into a trust?
So when you say put it into a trust, you mean like have the trust own the corporation? Because that I would not suggest doing because a corporation is a state-created entity. So if you have state property being owned by a trust, then the state now has an interest in your trust. But it's not necessary anyway. You can have these things flow in a way that the corporation doesn't have to be owned by the trust. It can just send money to the trust. So there's different ways of handling it, but certainly I would not suggest having the corporation owned by the trust.
Okay. Uh, why do we pay taxes at all or period? I do not support, Christine says, I do not support a satanic cult government that supports war. And there's some other comments around this. What
Amen.
would your response be?
I mean, yeah, why do we pay taxes when they just print as much money as they need anyway? I mean, for sure. But they're going to do that regardless. I mean, when you pay taxes, it doesn't even go to the war machine per se. I mean, it goes to paying the interest on loans that we have from, the banking families and set up, running through various international entities. So the tax dollars don't even go to what they tell you they're going to anyway. They're going to do it regardless of whether you pay your taxes, regardless of whether all of us pay our taxes, because again, our tax dollars don't support the war effort. They just print that money out of thin air. So we're interested in being left alone. We want to spend less time, with our nose in law books and more time with our families and enjoying our land. Equity is beautiful because it doesn't require you to learn case precedents, doesn't require you to memorize endless rules and regulations and try to beat the CRA at their own game. We give them something that they can use to get, to settle their ledgers with the central bank. And if you find that repugnant, then I mean, what better solution do you have to be left alone? I mean, if you want to have more time to spend with your family and be protected, protect those you love, you're going to have to give them something that they recognize. And so we teach you to do so in a way that doesn't use up the fruits of your labor, keeps all the wealth in your family, and keeps you from being attacked. So that's the best solution that I know of.
Thank you. We have a question about someone's son or daughter being taken away, and how can using your trusts perhaps get the son or daughter back? The son or daughter is safe, or the son is safe, but not in the mother and father's care.
So that's really more of a question for equity than a trust. There have been child protection cases that have been won with equity. It's a much more difficult battle because family court necessarily involves all sorts of character assassination and arguing and fighting, and you can't do that in equity. You can't argue, fight, or anything. You have to just ask questions. So there's ways of doing that, but it's going to be difficult for the person to emotionally overcome the desire to defend themselves. But if they can do that, then equity has discharged those types of cases. Now, when the child is already taken away, I mean there needs to be some kind of court action. You need to be able to get in front of a judge and let him hear equity coming out of your mouth in order to discharge the case. So I can't say I've dealt with a case where the child's already been taken from the parent and there's no more court. I think there's always a way of reinitiating a court process. You may have to jump through some other hoops, but you need to get back into court and start bringing equity and let the judge hear it in order to have a shot at getting the child back with our process anyway.
Got it. And my understanding from the bit I know, no expert here at all, is that it will take some time and a lot of study and research to be able to understand and embody what you're talking about in terms of equity. Would that be fair, Julian?
Yes, I mean, no one is motivated as a parent, right? But and equity is profoundly simple compared to other processes. I mean, again, it doesn't require you to memorize endless statutes and codes and rules and regulations and case precedents. And and all that. But yes, I mean, internalizing the process, requires you to shift out of anger and revenge, and a parent put in that situation that could be a very difficult thing to do. Requires you to embrace the far more powerful weapons of forgiveness and repentance. And if you can do that, then there's also quite a bit of courtroom dialogue to learn. But there is nothing that builds confidence for our students like the court role play, and understanding how to have that conversation with that judge and going to court a couple of times, and really getting to stand on the rock, and seeing the look on the judge's face when you say certain things. I mean, we have students that go up against the worst of the worst when it comes to judges. I mean, just the meanest people you can imagine. And if they stand firm, they might at the very end of that case get a wry smile from that judge and case dismissed. And you know, it's a huge victory. It's a huge boost in confidence. Um, there is a secret side to this system, and most of these judges are members of secret societies, and they don't teach us their rules. They're raised to understand certain things that we're just not taught in public school. But when you learn their laws and you learn their methods, and you stand in honor, not just morally, but according to their code of honor, and the few ways that it does overlap with our honor, our moral honor, they will acknowledge you, and they will let you go and leave you alone.
Thank you, Julian. Ian asks, are there different kinds of equity? And I would add, I think you referred to some, but could you be explicit about the different kinds of equity?
Oh, sure. I mean, there's exclusive equity, and there's a few other, specifically equity, larger jurisdictions. If you look in like Gibson's and Pomeroy's and Story's, these kind of equity treatises that were written before the 1930s. Of course, all that changed in the 1930s across the Western world. Um, Actually, Canada got started on that a little sooner than we did. I think it was more like the early 1900s or late 1800s when equity was merged into the overall commercial court system. But it was, around the 1930s when the rest of the Western world caught up and completed that process. So now equity is just all under their commercial court system. You have to show up to court in order to bring it, but we teach you how to have that conversation with the judge to make him put on his chancellor's hat, and cognize the equity that you're bringing, even within an admiralty, maritime commercial court.
Okay. I think we're almost complete. We have a couple of really, I think, quick questions. Would you want to put a private business in a trust, or at least all the income from it? Private meaning unincorporated.
It's always going to be more protected in the form of a trust. You're going to have more powers that give you the ability to be flexible in the commercial realm. So if anything were to ever come after that business, the trust is just going to make you more adaptable. And I mean, that's just a very broad way of describing what is a list of like several dozen powers that are afforded to trust that other entities simply don't get to use, or don't get to use as effectively.
Thank you, Julian. We are complete on this section. So appreciate you. Handing you back over to Karen Klassen.
Thanks, Esther.
Thank you so much, Esther. Brilliant as always. And Julian, incredible. You were so brilliant.